Dear faculty, students, and colleagues, I'm delighted today to welcome Honorable Justice Abhay Oak to our Orientation Day address to the incoming batches at the law school. Justice Oak is a distinguished jurist whose legal career has spanned over 4 decades, marked by a steadfast commitment to justice, fundamental rights, and the rule of law. After completing his BSc and LLM from the University of Bombay, he enrolled as an advocate in 1983 and began practicing at the Thane District Court. Early mentorship under Senior Counsel VP Tipnis, a former judge and Lokayukta, shaped his expertise in public interest litigation and complex legal matters. Elevated as an additional judge of the Bombay High Court in 2003 and made permanent in 2005, Justice Oak served there for over 13 years before becoming the Chief Justice of the Karnataka High Court here in 2019. He was appointed to the Supreme Court of India on August 31st, 2021, and he retired in May of this year. Throughout his tenure, Justice Oak authored over 380 judgments and participated in more than 590 benches, focusing primarily on criminal law but also contributing significantly to civil service and property law. His decisions constantly emphasized protecting liberty and fundamental rights. For example, during the CAA protest in Karnataka, he struck down police-imposed prohibitory orders, upholding constitutional protections for dissent and peaceful assembly. In a related case from Bidar, he condemned the illegal detention of school children and emphasized child rights, ordering corrective measures against police excesses. In his judgments, he has affirmed the right to lawful dissent under Article 19, warning that criminalizing legitimate criticism threatens democracy. His judgments have reminded courts and the police of their duty to protect unpopular opinions, reinforcing free speech safeguards. His environmental jurisprudence is notable. In MC Mehta versus Union of India, he has taken strong action against the unauthorized tree felling in Delhi's Ridge Forest, initiating contempt proceedings against the Delhi Development Authority and mandating afforestation. He has emphasized constitutional environmental duties, warning of demolition for non-compliance in afforestation cases, including major developers. In INRI's solid waste management, he addressed Delhi's untreated waste problem, criticizing and taking to task the government's non-compliance with solid waste management rules and highlighted health hazards from 3,000 untreated tons daily. In criminal law, Justice Oak has championed individual liberties and progressive bail jurisprudence. He has challenged the misuse of stringent laws like the Unlawful Activities Prevention Act and the Prevention of Money Laundering Act, advocating bail as the norm even in serious cases. His rulings in Abdul Sattar versus Union of India and Anil Tuteja versus Union of India reflect his concern over prolonged detention and judicial approaches to the potential misuse of money laundering laws. Justice Oak's judicial philosophy has combined compassion, integrity, and an unwavering pursuit of justice. His career stands as a testament to the commitment to liberty, equality, and the rule of law. His judgments have profoundly shaped Indian jurisprudence and continue to guide courts and legal practitioners in upholding constitutional values. We are fortunate to have him today with us, and we look forward to his counsel to the incoming students at NLS. I welcome Justice Oak to this gathering. Thank you.
Good afternoon. Dr. Sudhir Krishnaswamy, Professor Nigam, other faculty members and young friends. I consider myself to be privileged to address young students of this great university. I'm going to have a very limited address to you because I know that you had day-long session. My address will be followed by a brief question and answer session. Since I had demitted office of the Judge of the Supreme Court of India, I may have more freedom to answer your awkward questions. So I'll be welcoming those awkward questions. When I address you, I fondly remember Dr. Madhava Menon, the first Vice-Chancellor of this university. In Maharashtra, government decided to set up 3 national law schools at the initiative of the Bombay High Court. We had requested Professor Madhava Menon to guide us. I remember in 2014, in a meeting held in High Court Conference Hall, there was a debate. There were 3 retired judges of the Supreme Court from Maharashtra. They were insisting that National Law School in Mumbai should not be set up unless complete infrastructure is made available. Professor Madhava Menon was there. He said that this great institution, which is always on the top of the list of national law schools, or any law school for that matter, was started from a garage. And I had great privilege of working with him as a member of the selection committee of Vice-Chancellor of National Law School in Mumbai. When I visit such a top national law school, I am always reminded of my old days as a student of law. For the benefit of young students, I must tell you that the education in law has completely transformed itself. I was student of Government Law College, which is still the oldest law college in India, in Mumbai. I got admitted in the year 1980. I have still kept with me the identity card of first year LLB course. The reason is the identity card shows that first term fee which I paid was rupees 124 and second term fee was rupees 87. And we had in those days part-time course, only part-time course. So we used to have that afternoon batch. I got into afternoon batch. There used to be early morning batch between 7 to 10 and afternoon batch from 11 to 1 or 1:30. I must tell you, in those days, there used to be only one moot court competition every year, one moot court competition. There are no other competition. We had not even heard of mock trials or any other competition. And we used to have maximum 2 or 3 lectures per day. Of course, there was a great Professor Balsara who used to teach us criminology and other subjects in criminal law. But otherwise, they're all practicing lawyers or solicitors in Mumbai. So barely there used to be 2 lectures per day. But the Government Law College had a great advantage about its location. It was very close to Bombay High Court. It was very close to another beautiful place, British Council Library. We are fascinated by British Council Library for different reasons. In those days in 1980, they used to show beautiful video films. And we could go there, see the video films, take out any book in the library and read there. And third, and perhaps the most important place for us was Wankhede Stadium, which was very close to Government Law College. And in those days, we used to spend 1 rupee, purchase a ticket in North Stand, and could see Gavaskar, Vishwanath, Brejesh Patel, Chandrasekhar, and so many great stalwarts in action. We used to watch Ranji Trophy and Duleep Trophy. I had great fortune as a law student to hear the great H.M. Sirvai arguing in Bombay High Court before a full bench. I must confess that as a first year student, I did not understand what were the submissions. But he had become blind, and without help of anybody, he was telling the court the page number of the paper book and what a particular judgment of the Supreme Court, what a particular paragraph of the judgment in the Supreme Court, he was telling the bench. Young friends, I want to tell you something different. This was the kind of legal education in those days. And I must also confess that in those days it was said that those who could not secure admission to any professional course, as a last resort, they used to join law. Of course, I must hasten to add, I was not one of them. Though I had other career opportunities available, I, for some reasons, decided to join law. National Law School is a concept which evolved here in this place. And all of you must know one thing, all national law schools in India, they are established on the land given by the state governments. And they are initially, they're all funded by the state government. So in a sense, public money has been spent on setting up these establishments. The education in law took a very important turn, I think, in late 80s or early 90s, when universities were permitted to start 5 years degree course in law. And that was when the talent started returning back to law. And of course, the national law schools came up, private law schools came up, and the entire face of legal education has undergone change. And therefore, I always tell when I visit any national law school that you belong to privileged generation of law students, where you have such beautiful facilities. Of course, this place is very special. This university is always on the top. So you all belong to privileged generation of law students. I know that from morning you must have heard the Vice-Chancellor and other faculty members telling you about this course, what you are expected to do, etc. I want to tell you something different. As this institution has come up on a government property, initially with the government aid, and as all of you know, that Bar Council of India, which is again a statutory body under the Advocates Act, had taken initiative to set up this university. So therefore, when such facility, such great facility, excellent educational facility comes up, I believe that this facility must give back to the society. And in what manner it can give back to the society, I want to briefly touch upon that. I know that you have dreams when you got into this admission to this prestigious law school, and you must be all toppers in CLAT, and you must be dreaming about your career. So what is that career? I want to emphasize on that. Of course, many of you must be eyeing on career in leading law firms. Many of you may be fascinated with practice in the field of IPR. Many of you must be thinking of joining practice in arbitrations. What are the options available before you? According to me, it is my, of course, personal view, you are entitled to differ. One of the best options, perhaps the best option available to intelligent students like you when you pass out with a degree of this prestigious national law school in your pocket is litigation practice before the traditional law courts. When I say traditional law courts, I mean our trial and district courts, High Court and Supreme Court. You'll be studying Constitution. Normally, there's a practice to call High Court and Supreme Court as constitutional courts. But there are 5 to 6 articles on our trial and district courts in the Constitution, which those articles deal with appointment of district judges, the process of appointment of our civil judges. So in a sense, they are also constitutional courts. I will give you an example of one of the greatest lawyers India has ever seen, Mr. Ram Jethmalani. I hope that you have heard about him. When I began practice, he was a living legend for us. Remember, Ram Jethmalani started his career from the courts of magistrates. And as a lawyer, I have seen him appearing in the courts of metropolitan magistrates in Mumbai. According to me, the most challenging career for brilliant law graduates is practice before the traditional courts, because that is one practice where you always require thinking on your feet. If you become a trial lawyer, you have to be a very skillful cross-examiner. And cross-examination is a very fascinating thing. Cross-examination is not about raising your voice as you see in most of the films. Cross-examination is something about understanding the mind of witness. Cross-examination is something which requires you to make the witness comfortable and get the answers which you want from the witness. Appearing before the constitutional courts like High Court and Supreme Court is very challenging. And why I say that this is the best available field, because I must tell you that as Justice Chagla, Chief Justice Chagla, great Chief Justice of Bombay High Court, has said in his book that nothing succeeds like a success in legal profession, traditional legal profession. I'm not talking in terms of money, because I can share this with you that when we talk about bigger cities like Bombay, Delhi, Bangalore, Madras, legal profession, traditional legal profession has become most lucrative profession. I'm not stopping at that. Why I say traditional practice before the traditional courts? I always say this when I talk to the young lawyers, that practicing before our traditional courts is five-star social work. Why I say five-star social work? Because if you are successful, and young bright minds like you are bound to be successful, you earn a lot, and while earning a lot, you can do a lot of pro bono work. You can appear in legal aid cases. You can defend poor people who are languishing in jail and see that their rights under Article 21 are made available to them. You can appear for various charitable organizations which are doing great work in our country for poor and downtrodden. So it's a great opportunity for you to do social work, to give back to the society while you earn handsomely. And as I said, that these are all institutions which have come up by using public funds. These institutions must give back to the society, because ultimately, if we have brilliant lawyers practicing before traditional courts, it will improve quality of our justice delivery system. Quality of justice rendered by the courts, maybe our trial courts, district courts, high courts and Supreme Court, it depends on quality of the bar, the assistance which is given by members of the bar. And therefore, the success or failure of the legal system always depends on the lawyers, the members of the bar. And therefore, if you become part of traditional legal profession, you serve the cause of justice. Ultimately, judiciary is one institution which is so important that common man looks upon the institution for getting justice. There are people who languish in jail for years without getting justice. They look upon the constitutional courts to grant them benefit of liberty under Article 21. So that's a huge challenge to work before the traditional courts. This is one career which is a very fascinating career. Another career which I want to talk about is career in judiciary. And I'm so glad that alumni of this very great institution are now occupying good positions in judiciary. We have 4 or 5 sitting judges of Karnataka High Court who are alumni of this great institution. Why I am talking about judiciary, I want to give great deal of emphasis. Keep aside the salary part. You may be under impression that the judges are not paid adequately. I'll deal with that little later. But I am on beauty of job as a judge. You know, if you are a brilliant lawyer, you have command over, for example, you are a specialized constitutional lawyer, or you are a specialized criminal lawyer or corporate lawyer. Even if you are very brilliant, if you are very equipped with all nuances of law, there are inherent limitations of your performance. What are those inherent limitations? You may have a very aggressive opponent as a lawyer who marches ahead of all lawyers appearing in the case, is so strong. You may have a very cantankerous client who will not be satisfied about services rendered by you, notwithstanding skills practiced by you. And one more thing, you may be facing hostile court, hostile judges who are against you. So therefore, when you are a lawyer, your performance is constrained by several external factors. Look at the position of a judge. You are a session judge, you are a judge of the High Court. When you sit single on the bench, there is nobody who can control your performance. Perhaps your performance is controlled by your own conscience and the 4 corners of law. Only law and equity controls what you do as a judge. And that's the most fascinating part of judgeship, that you are on your own. No external factor controls you. And mind you, when you sit as a judge, you get great satisfaction. Even if you give justice to somebody, one person who has suffered injustice, you derive great satisfaction. And I must tell you, I practiced for almost 20 years in Bombay High Court, first 2 years in trial court and thereafter in Bombay High Court. And I worked as judge of three different courts, Bombay High Court, Karnataka High Court and Supreme Court for 21 years, 8 months and 25 days. But I can tell you from my own experience that the work satisfaction you get as a judge cannot be compared with the work satisfaction you get as a lawyer. Of course, you must earn. Earning is also important. You must have a good lifestyle. But at the same time, if you consider yourself to be expert in a particular field, you must get that satisfaction of rendering service, satisfaction of rendering justice, and that's very important. Another career which is very important according to me is career of teaching in law. It is because of these great teachers, two of them are sitting here, that these institutions have prospered. The teachers in law, like starting great tradition, started by Professor Madhava Menon. It is because of these great teachers that we have great legal scholars. We talk about perhaps greatest surviving legal mind, Professor Upendra Bakshi. Ultimately, he was also a great teacher. Today, he continues to be a teacher in different capacity. So, as our legal system needs good lawyers and good judges, our legal system needs great law teachers. Another field connected with teaching is very important. I must say that I am not a jurist or expert in law. I am saying this only on the basis of my own experience, my own understanding of the situation. I believe that in our country, in true sense, there is no legal research. Whatever research, if we call it as a research, takes place for writing thesis for doctorate. So there is no in real terms, real legal research. And there are many areas available for research. In 1860, the British government came out with Indian Penal Code. And we have a new version of that in 2023. And the new version is not different from the old version. Some changes here and there. Section X section becomes A section in the new act. But has any legal research taken place from 1860 in the context of situation in India, rapidly changing situation in India, about these penal laws? I'll give an example of a law which is in controversy. Of course, there are early days for you, but you must have heard, because as you are students of this, you have taken admission, you must be already interested in legal subjects. Prevention of Money Laundering Act. It has become such a controversial thing, and there is allegation that it is being misused. You must have read recently that two distinguished lawyers were issued notice by Enforcement Directorate. They wanted to know what advice the lawyer had rendered to some litigant who got entangled into offense under the PMLA. Now, why these laws are not effective, or why we have such laws which can be misused? The reason is that there is no real legal research before the laws are enacted. Oh, I go back to 1860. Look at Indian Penal Code, section 279, which makes a rash and negligent act causing injury as an offense. In 1860, nobody contemplated so many vehicles on the road. But after so many years, after so many decades, it takes care of offenses on the road. So some legal research, lot of thinking must have taken place before Britishers formulated Indian Penal Code. But we do not have that expertise because we don't have that research happening in our country. So therefore, teaching and research in law is very, very important avenue available to you and open to you. Now let us come to monetary part when I talked about entering judiciary. Today, some of the senior IAS officers make a grievance. I happen to be member of two committees for appointing members of some tribunals. One was Central Industrial Tribunal, one was another tribunal. And as per law, some of the civil servants were members of that selection committee. We used to complete our work and then we used to have discussion over a cup of tea. Their grievance was that as compared to the starting pay of IPS and IAS officers, a judicial officer who has practically no experience of working as a lawyer and who becomes a judicial officer even at the age of 25, 26 or 27, he gets more starting pay than IAS and IPS officers. He gets more perquisites like rent-free residence, petrol allowance, driver allowance and whatnot. So therefore, gone are those days when it was considered that entry in judicial service at the grassroots level. I'm not using the word lowest level because they are not lower courts or subordinate courts. They are trial and district courts. So entry in judiciary at grassroots level at one point of time was considered as not at all a lucrative thing. But things have changed. And now today we have a better pay structure and better perquisites to the members of the judiciary. And please remember one thing, when we talk about career in judiciary and what kind of emoluments judges get, we can't compare that with the staggering amounts which successful lawyers get. The reason is that, as I said, the work satisfaction you get as a judge is far, far superior and far, far more than what you get as a lawyer. So these are various options available to you. I know that it is too early to talk about your future, what career you should adopt. I am doing only one thing. I am only setting your thinking process. You will start thinking about your career. Today, of course, there will be people who will be telling you that you should eye on joining corporate field or you should eye on joining firms. And I'm sure in a great institution like this, there will be campus interviews. So many law firms will be coming here and law firms will be picking bright students from this great institution. But of course, there are students who need to earn immediately after they complete their graduation. And for them, of course, there are compulsions because legal profession is such that you may not start earning immediately. I understand those who have pressing need to start earning, they go into the firms and working there. But I believe that those who can afford to wait for some time, those who can afford to struggle for some time, they must consider these better options of practicing before the traditional courts. I remember attending one such function in one of the private law schools in India, where I said something not exactly the same but in different words. But there were people who addressed the students when I was present, telling the students that, look, the judiciary in India is facing, judicial system in India, not judiciary, judicial system in India or justice delivery system in India is facing huge challenges. There are huge delays. And people talk about crisis of quality of justice rendered. The quality of justice is not good. Everybody says that. Then I told the students, there was question and answer session. I told the students, if you feel that Indian judiciary is not performing, it is not up to the mark, that itself poses a great challenge before brilliant students and would be brilliant law graduates like you. And that is where you must start thinking about it. And these are the 5 years you will get opportunity to look at not only the laws which apply to our country, but also look at how our judicial system is operating. You will be told about arbitrations. You will get an opportunity to understand whether arbitration is success or failure in India. You also know how the Commercial Courts Act has operated in India. So please keep your eyes and ears open and use this period of 5 years to look at our legal system, understand the challenges before the legal system. And that is what I wanted to convey to all of you. I can go on, but I know that you have a long day and you will get used to such long days after your regular curriculum starts. You should be ready for that. So before I close, I congratulate all of you for getting admitted to this great institution. And I also look forward to a day when some of you will become great, successful lawyers in our legal system. Some of you will become great judges of our judiciary. I wish a great success to all of you, and I know that you'll go back enriched from this institution, and whichever part of the world you land up after your graduation, whichever field you land up, you'll achieve a great success. I thank Vice-Chancellor for giving me this great opportunity to interact with these bright young students. Thank you. I did better. That's it. Look at me.
Okay, so let's open up to some Q&A. Some hands. Oh, now there are a lot
So
of
many
hands.
hands.
They're warmed up, sir. In the morning when I asked them, there were barely any hands. I'll just start with you in the red shirt. If I can just get a mic there, we'll just circulate it around.
A very good evening, Your Lordship. A very good evening, all the teachers, and a very good evening, everyone. My name is Gaurav Chawla, and I have enrolled for the LLM program for this year. Sir, as I was listening to your speech, you were telling us that the legal profession and the litigation aspect is very lucrative in long term. It has some struggles, but in long term, it is very lucrative and it is a very good option. Sir, having done my UG, the 5-year course, and having done multiple internships, there were few concerns that I had with regard to the practices in the lower courts, or I would not say lower courts, I would say the district court and the trial court. The concern was, sir, stipend is something very secondary to this. The primary concern was that the merit is not very much respected when I talk about, I don't know about other states, but to an extent when I talk about Uttar Pradesh, the merit is not very much respected there. Also, sir, when I talk about how people look at juniors, how people treat them, how secondary character is being given to them. So it is not very lucrative for them to go on and on in this profession. So how should we as juniors look forward to this, and how should we stay motivated enough to have this capacity to go through all this for 4 or 5 years? Thank you, sir.
See, what you said itself is a challenge. I mean, I agree with your sentiments that you feel that merit does not have place. I understand what you are saying. You may be feeling that there are undeserving persons who are getting successful in the profession. Is that correct? See, as I said, you are right, but that itself is a challenge. If you consider yourself to be very competent, you are good in law, the system needs you. And ultimately, if you read Justice Chagla's autobiography under the heading Chapter The Bar, please read that chapter. That's what he has said so many decades back. He said that as a junior lawyer, you have to show a lot of patience, and you will see undeserving people flourish in the practice. But if accepting that there are challenges in the trial and district judiciary, if every bright student like you, or bright law graduate like you, starts thinking, who will bring about a change? If bright law graduates like you, 10 people start practicing in a particular district court, if you show patience, slowly the litigants also want a quality lawyer. It may be period of struggle for 4 years, 5 years, great struggle, I'll put it that way. But ultimately, I believe today situation is not bad in our country, in our legal system. Someday your merit will be recognized. And look at the effect. Let us take an example of one district court where you say the lack of quality and so many other issues, secondary issues as you call it. If 10 people like you start practicing in such a court, maybe after 20 years, the picture of bar in that particular court will be completely different. So it's about accepting the challenges, because if you want to bring about change in our legal system, I always said on public platforms during last 15 years that yes, our system is facing crisis of credibility. And if our system is facing crisis of credibility, brilliant minds like you, brilliant people like you must take it as a challenge. Because ultimately, if our legal system is not going to improve, if our legal system is not going to render justice to common man, what is the use of having legal system? And that is where there is relevance of people like you. That's a challenge.
Good evening, sir. This is Siddhi Ladda. I am starting with my BA LLB course. Because I have the privilege to interact with a Supreme Court Justice, former Supreme Court Justice, I wouldn't pass upon the opportunity to ask this question. What is one piece of advice you would give to students who have all of law school left before us, as somebody who's seen the profession from the bar and the bench, that we should hold on to and actively work on?
If you want to succeed in profession of law, your fundamentals have to be clear. Fundamentals have to be clear in the sense that what is the foundation of our criminal jurisprudence. Now we have a system where guilt of an accused has to be proved beyond reasonable doubt. Now you must, to begin with, understand these basic concepts. If you know what is our criminal jurisprudence and why this concept of proof beyond reasonable doubt, then as you grow as a student, as you grow as a lawyer, understanding new criminal laws or concepts, sections in the criminal law, that becomes very easy. And apart from that, I'm just giving you an example of criminal law. The traditional concept still remains. Proof of guilt has to be beyond reasonable doubt. But of course, there are presumptions. There are special statutes which are exceptions to this rule. For example, in this Narcotics Act, if you are found in possession of narcotic substance, then the burden is on you to explain. There is a similar rule in section 106 of the Indian Evidence Act. If something is within personal knowledge only of the accused, the burden shifts on the accused. So, most important thing is to understand the basic concepts. For example, law of contract. Law of contract in India is slightly different concept than law of contracts in some other countries, developed countries. So if you understand, if you go to the basics, the philosophy and the principles behind our legal provisions, that will make your journey as a lawyer or a judge very easy.
Good evening, sir. I'm Sanskriti Pathak, a first year BLLB student. Sir, recently we had a judgment by the Honorable Supreme Court that mandates 3-year practice before a person can appear for the judicial service examinations. So, sir, do you really think this will produce more competent judges, or does this experience doesn't have a very crucial role on producing more competent judges? Also, sir, why does India doesn't have all India judicial service examination?
Right. I'll answer the second question first about All India Judicial Service. You can take your seat. You can take your seat. For that, you must understand the. Basically, I must say one thing. On first principles, this concept is correct. If there is All India Administrative Service, All India Police Service, why not All India Judicial Service? If you go to all the states in India, the principle or the law is that the proceedings of trial court are conducted in regional languages. And unless you have command over the regional language, you won't be able to discharge your duties as a judge. I'll give you an example. Take a case of a criminal trial. The witnesses will be, suppose you are in working in court in Karnataka, most of the witnesses will be deposing in Kannada language. The depositions will be recorded in Kannada language. And what is important in criminal trials is appreciation of evidence. How do you appreciate the evidence? Because only after you appreciate evidence, you can decide whether the version of the witness is truthful or is telling the truth. Now, for appreciating evidence, you require very sound knowledge of the local language. For example, if you sit on the civil side, say in a city civil court in Karnataka, there will be issue of interpretation of documents written in Kannada. And you know, every regional language in India is very rich language, where one phrase can have 2 or 3 different meanings. One word can have 2 or 3 different meanings. And therefore, when you want to work in trial courts in a particular state, you must have that kind of knowledge of the local language. One suggestion which was made was there need not be all India judicial service, but there can be a common mechanism by which judges are selected, in the sense that the pattern of examination is same. Whether you appear for entrance exam in Karnataka or in Uttar Pradesh, you have to answer the same examination. That is a matter of debate. Now, what was the first question? Just repeat. 3 years practice. Now, I must say, as I began by today saying that I had little more freedom because I had limited office very recently. It's a matter of huge debate. I will tell you what is that debate. I have been teaching in various judicial academies across India for last several years, especially Judicial Academy in Maharashtra for last 12 years. One perception was that young law graduates who have not seen, they have not even seen the court, they enter judiciary. And the training which we impart is firstly academic training and some experience in the form of mock trials. And when they sit in the court, they have not seen how the courts function. How the courts function in the sense, in practical sense. They may be good in theory. And therefore, one thought process was that let us have civil judges who enter judiciary at grassroots level who have seen the functioning of the court. This is one argument which is very attractive. The other argument is twofold. In 50s, in many states, including at that time it was state of Mysore, then state of Bombay, there was a practice that a student who stands first in merit in university, he was given option to directly enter judiciary. That was prevailing in many states in India. And I have seen some of the judges who were High Court judges by the time I became a lawyer. And some of them did exceedingly well. Obviously, they had no experience of working in the court. This is the first argument. The second argument against this 3 years business is that now the exam for entrance exam for judiciary also become very tough. If you go to North India, you will find on every newspaper there are a number of advertisements of coaching classes. It may be true in this state also, I do not know. What will effectively happen is that experience will be only on paper. That you apply for registration to local bar council, you will get that document known as sanad in popular parlance, and you may not enter the court also. You may show that you have joined some senior, and you will continue to study for your entrance examination, do several other things. So this 3 years experience will remain on paper. So both are equally good arguments. Of course, I see a point in what you are saying. And to some extent, selfishly, I had doubts about this 3 years business. The selfish reason is, if there is a young, bright law graduate who is aspiring to join judiciary, if this 3 years condition is not there, judiciary will get extremely talented person. But if such person goes and starts practicing in court, maybe within 2 or 3 years, he'll be immensely successful. And then he'll feel, no, I have such great opportunity to earn, why should I join judiciary? So this is one angle which strikes me. But you are right, this requires a lot of debate. And perhaps I must tell you, see, these are the orders which are passed by the court. You must have seen the trend of orders in that particular litigation where these orders are passed. See, this is part of, transformative law. And maybe with the experience of few years, perhaps judges may take different view also. But I agree with you that it's an area of concern.
Good evening, Your Lordship. I feel so blessed that I got a chance to talk to you. So my question is related to criminal justice. For advocates, their goal is to serve the best interests of their clients. But when it comes to criminal justice, and it is so obvious that the client has done a crime so heinous that it could shake the core of a society, and even the advocate feels like the client should rot in jail, then how does one keep up with the best interest of their client as an advocate?
See, I am very glad that you asked this question. There is slight error in your approach, because I don't blame you, because this is the view shared by so many intelligent people in our society. Many people feel that once investigating agency or police accuse that a particular person has committed an offense, we presume that he is the offender. Legal mind has to work differently. There is a very heinous offense which shocks the conscience of the society, conscience of every human being. For example, offense against women, offense against children. No doubt that there is an offense, but on what basis you say that because police make allegation, police file a charge sheet against a person, he is the offender, for which whether he is offender or not, that requires complete criminal trial. It requires evidence to prove his involvement in the offense. I must share this with you. I never practiced on the criminal side as a lawyer. Maybe initially I also carried the views which you are saying today. When you start working actually either as a judge or a lawyer, you realize what is the truth. I'll give you an example. In 2005, I was taking criminal bail roster, judge in charge of deciding bail applications. There was a case of double murder in one of the prominent districts in Maharashtra. There are 4 accused who were arrested. They were denied bail by the Sessions Court after investigation was complete and charge sheet was filed. I denied them bail on the basis of statements of certain witnesses recorded by the police. Now I want to tell you something very interesting here before I go further. It's too early for me to tell you what is the law on the point. The statements are recorded by a police officer of witnesses. Sometimes those statements are not even signed. It is the version of that police officer which you find in that statement. And ultimately, the witness whose statement is recorded by the police, which is not admissible in evidence. Whatever a witness says before the police is not admissible in evidence. It can be used for limited purposes. That witness has to go to the court and tell the court what exactly happened and whether same offender is involved. So coming back to that case, so I denied bail. Because the law is that once a particular judge denies bail, if second bail application is made, it must go before the same judge. Second bail application came to me, and to my horror, I found that after I had rejected the bail application, widow of one of the victims filed a petition in the High Court, writ petition under Article 226, High Court directed investigation, fresh investigation to be made by a senior IPS officer. And senior IPS officer on investigation found that set of 4 accused who were shown as accused were not the real accused. Somebody else was the accused. There are cases and cases. I can tell you this, even during last 6 months of my career, I must have granted acquittal to certain accused who had spent 12 years or 13 years in jail because they are convicted for offense of murder. Culpable homicide culpable homicide amounting to murder. And some of the cases were of no evidence. As you gain experience, you realize how our investigating agencies function. I am not saying that all investigation agencies are bad or all investigations are defective or all investigating agencies act with motive. But fact remains that there are instances and instances where innocent persons, and when I say innocent, I say in terms of law. Innocent person in the sense that against whom there is no legal evidence to show that he has committed offense. So therefore, when you sit as a judge, I'll tell you a very interesting thing. I attended a workshop of doctors. The workshop was about various laws regarding medical negligence, in which cases doctors can be sued for compensation, etc. Different topics were there. So one doctor asked me, when you know that a particular person has committed a crime, how do you let him off? How do you grant him bail? When we sit in the court, we know that there is an offense in the sense that there is a murder. So there is a dead body found. There will be post-mortem report which will say that somebody has stabbed this man and cause of death is that stab injury, stab wound in the stomach or in the chest. When we decide a criminal case, what we have to decide is whether we don't decide whether the accused who is before the court has committed the offense. What the judges are supposed to decide is whether there is legal evidence in terms of law of evidence, burden of proof, etc., to prove that the person who is named as an accused has committed the crime. That is the duty of the court, to see whether there is evidence. Therefore, as a lawyer, you need not start with the impression that whom I am defending. Because as you grow old, you realize there are cases and cases where people are framed. And ultimately, what is the job of a lawyer? Job of a lawyer is to uphold law. And what is the law? That unless there is legal evidence to show that a person has committed crime, he cannot be punished under our system, under our legal system. That's the function of a lawyer. So don't go with that fixed mind that because police make allegations, person has committed a crime. The concept of law is completely different.
Good evening, sir. My name is Kaustubh Krishna, and I am part of the incoming batch of BLLB. My question is, for many students present in this house today, including me, who were planning to enter the judiciary through state judiciary examinations, what's now better for us that the SC has passed the judgment, mandating 3-year experience? Do we wait 3 years and write the judiciary examinations, or do we wait 10 years and write the higher judiciary examinations?
Yes, that's a good question. The structure, you must understand the structure of our district and trial judiciary. It's like a pyramid. The base is very broad and it tapers like this. So at grassroots level, when you enter judiciary as a civil judge, you have more posts available. But coming to you are saying that after 10 years you can apply for appointment as a direct district judge. I believe that only 25% of the total posts of the district judges are reserved for direct recruits. So the chances of getting into judiciary reduces. But still, it has advantages in the sense that if you enter judiciary as a district judge, then there are more chances of you reaching the High Court. That is also correct. So therefore, it's a very difficult decision to take, whether to apply after 3 years, where you have more chance of getting into the judiciary, or you take the risk of waiting till 10 years and then try to enter the judiciary where the competition will be more stiff. So it will be an individual decision.
Good evening, sir. My name is Akela Divya, and I'm first year student in BLLB program. So I come from a background where I've had people tell me that anything, just judiciary or litigation, these fields are not suitable for girls. Like they still say stuff like this. So like there have been instances of like harassment or discrimination against female lawyers or juniors. So all of these things are quite disheartening, and at the same time these are the factors that demotivate us from entering into like litigation and judiciary. And this roadblock of 3 years mandatory practice as well. So we who come from common households where we have responsibilities, and at the same time people just keep stopping you, your family, or uh, people close to you, or the societal pressure is there, where you're just constantly just told that this isn't suitable for you. So sometimes I think some words of advice and motivation from you would help to just keep going forward in this field, and some words that I could remember for rest of my life to just, keep pushing forward. Thank you, sir.
See, today, very unfortunately, uh, there are problems faced by girls or women in all fields, not only confined to the courts. About judiciary, I want to tell you something interesting. Last 4 or 5 years, I was part of selection committee of civil judges or district judges. Last 4 or 5 years, without an exception, in all states, we have a scenario where after we recruit the civil judges, more than half of newly appointed civil judges are women. And very shortly, I have seen judiciary very closely for last so many years. Very shortly, we'll have a scenario where that percentage will go to 60 or 70%. So women will be occupying positions of chief judicial magistrates or principal district judges. And therefore, women will be in better position to prevent all these things which happen in any institution. Any institution, the women or girls will have to face this. So in judiciary, I can tell you that the women are already in majority. 2 years back, I addressed Judicial Academy in Bihar, where the newly appointed judges during last 3 years were present. I was told in these 3 batches, the percentage was 60% in Bihar. So therefore, you don't have reason to worry as far as judiciary is concerned. If you are talking about legal profession, yes, I also get feedback from my interns, my former law clerks or present law clerks. Women do face difficulty, but there also now situation is changing very fast. If you go to family court in any important city, important in a sense because it's a populated city, you will find now at least 50% of the lawyers who practice in family courts are women lawyers. While I agree with you that there may be some problems, that apprehension will be there, but I think this scenario will undergo change. Now, as I have seen legal system for last 40, from 1983, I find that now stage has come, maybe after 5 years or 10 years, women are going to dominate the judiciary. So I don't think you should have that apprehension.
Good evening, sir. I'm Chinmay Nayak. I'm joining the 5-year BA LLB honors course. So, in your speech, you had mentioned about Ram Jetalmani and the art of cross-examination. So in an interview, Ram Jetalmani had said that the art of cross-examination is being lost in the modern world. So, as per you, what is a skill that's being lost in the newer generation of lawyers and something that we must inculcate in learning throughout our next 5 years? And how can we as individuals uh, contribute more towards?
Yes, I think
Yeah.
I'll make only a few points. Point number one, I don't fully agree that art of great art of cross-examination has disappeared, but it has been considerably affected. The reason is that there is perception in the mind of young law graduates. They feel that practice before our trial courts, sessions courts or magistrates court is something which is inferior to the High Court or Supreme Court. Therefore, talent goes there. The second reason is that the times have changed in the sense that when I joined practice, we were told that to become successful in terms of getting lot of work and getting lot of money, you have to easily spend 8 or 10 years. So we were told, we are brought up in that culture that I have to remain happy with little or no practice for 7 to 8 years, and you have to work very hard in those days. The art of cross-examination takes time to develop. It requires a lot of patience. You know, it's like doctors experimenting. You know, somebody suffers from incurable disease, and doctors experiment. It's like experimenting. I mean, when you start cross-examination, sometimes you may falter. You may end up in not asking very important questions which may affect future of your client. So it takes time to develop art of cross-examination. And unfortunately, due to change, societal changes, etc., I think some of the young law graduates do not have that kind of patience. So to some extent, I agree that it's a dying art, but it has not died down. You go to many districts, important districts, and especially districts which are not so urbanized, you will find that art of the brilliant cross-examination still you will find in those districts. It is not dying down. It is something about the approach of young law graduates. And I mind you, I had done work of cross-examination maybe for 2 or 3 years. It's such an exciting job. I mean, you have to think on your feet. Every witness is different. His psychology is different. His understanding is different. His family background is different. His approach is different. So you have to be good psychologist when you cross-examine a witness. And that's a great challenge to cross-examine a witness. So to some extent, yes. But still, I have great hopes that this art will not die down.
Honorable Justice Oka, thank you for taking the time to be here with us today. Your presence here gives us students who are only beginning their educational journey with us the opportunity to preview a long and successful career at the bar and in public service. May I request Professor Nigam to present Honorable Justice Oka a small token of our gratitude and invite all of you present here to join your hands to show your appreciation. Justice Oka was the Chief Justice of Karnataka from 2019 to 2021. As I took my first tentative steps in my role at NLS, he was a constant source of support and encouragement. His drive, energy, and commitment to expand access to legal education while sustaining the highest achievable quality allowed this university to make strong progress in the last few years. Thank you, sir, for your support, and we look forward to welcoming you back to the university to engage and teach in our classrooms in the near future. This orientation program was anchored by Professors Ashna, Amel, Akila, Debangana, and Rahul, most of whom are here. I think we owe them our thanks. And they were supported by colleagues in the IT department and the facilities team, some of whom are here. I don't see Dr. Joel Xavier, but he was pulling much of this event together and made this possible, so we owe him our thanks. And we look forward to seeing all of you bright and early tomorrow morning in a classroom somewhere. But before we go, may I request all of you to remain standing as Justice Oka departs from the venue.